and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we update you with the latest legal developments across the country. Starting with the headlines. Supreme Court continues hearing of the Aligarh Muslim University minority status case for the fifth day. Supreme Court cancels bail for DHFL promoters in multi-crore bank loan scam. Rajasthan High Court dismisses PIL, challenging appointments of deputy CMs. Killer Jeans moves Bombay High Court, claiming trademark infringement by Netflix series Killer Soup. Now the headlines in detail. A 7-judge bench of the Supreme Court, headed by the Chief Justice of India, D.Y. Chandrachud, and also comprising Justice Sanjeev Khanna, Justice Suryakant, Justice J.B. Pardiwala, Justice Dipankar Datta, Justice Manoj Mishra, and Justice Satish Chandra Sharma, continue to hear arguments for the fifth day today in the Aligarh Muslim University minority status case. Solicitor General Tushar Mehta presented his arguments and highlighted that as per the Act of 1920, which led to the establishment of AMU, the law director was the Governor General, and that the visiting board had no Muslim. The SG said university was subordinate and subservient to a body of non-Muslims. SG Mehta argued that even the day-to-day administration of the university was not in the hands of the minority. Justice Khanna in this regard said there are two ways to look at it. One from the point of view of day-to-day administration, and another is with whom the final power is vested. The SG submitted that the question is who is the ultimate decision-making authority in terms of administration with absolute and predominant control. The CJI made the observation that the court shall proceed to determine the validity of the provisions of the 1920 Act as it stands and see its impact on the minority status. The SG requested the court to not read the 1920 Act in context of Article 30 of the Constitution, as at the time there was no concept of constitution or fundamental rights. On this, the CJI stated that we cannot say that a pre-constitution institution cannot claim a right under Article 30 and clarified that for establishing such claim, two yards must be satisfied. The first being the establishment of the institution by a minority and the second of it being administered by a minority. In a significant development today, the Supreme Court has revoked the bail granted to former Diwan Housing Finance Limited promoters Kapil Wadhwan and his brother Dheeraj in connection with a multi-crore bank loan scam. The decision was made by a bench comprising Justice Bela M. Trivedi and Justice S.C. Sharma, who declared that both the trial court and the High Court had made errors in their previous decisions to grant bail to the Wadhwan brothers. The apex court firmly asserted that the brothers could not claim a statutory bail as a right, given that the charge sheet was timely filed and the cognizance of the case was taken appropriately. Statutory bail is typically given when the investigating agency fails to file a charge sheet within the specified period of 60 or 90 days, as outlined in the Code of Criminal Procedure. In this particular case, the FIR was lodged by the Union Bank of India, and the Wadhwan brothers were taken into custody on July 19th of the preceding year. The Central Bureau of Investigation filed the charge sheet dated October 15, 2022 on the 88th day following the registration of the FIR. In furtherance, the trial court granted default bail to the accused individuals. The same was subsequently confirmed by the Delhi High Court. Notably, the High Court, while granting bail, had clarified that it did not delve into the merits of the case. The Rajasthan High Court has dismissed a public interest litigation challenging the appointments of Diya Kumari and Prem Chand Bairwa as Deputy Chief Ministers. The petitioner, Om Prakash Solanki, argued that the said post of Deputy CM is not recognized by the Constitution of India, and so the appointments of persons as such be cancelled. The PIL filed on December 16th, a day after Kumari and Bairwa took oath, was placed before a bench led by the Acting Chief Justice M.M. Srivastav, who held that the PIL lacked substantial material and deemed it a mere public stunt by the petitioner, who is an advocate by profession. Consequently, the court not only rejected the PIL, but also imposed a penalty of 25,000 rupees on the petitioner. In an interesting development, Keval Kiran Clothing Limited, the owners of popular Killer Jeans brand, has filed a commercial suit before the High Court of Bombay, alleging a trademark infringement by Netflix series Killer Soup. The lawsuit alleges that their registered trademark Killer has been associated with KKCL exclusively and widely recognized by the general public, making any product or service sold under this mark immediately linked to the company. The company contends that the mark used by the makers of the Netflix series is not only identical but deceptively similar to KKCL's registered trademark. The company has sought an order to permanently restrain the defendants, MacGuffin Pictures and Netflix India, for using the name Killer Soup or any other mark resembling the registered trademark. Additionally, KKCL has requested the court to issue directions to remove Killer Soup mark from various social media platforms associated with the makers as well as the actors. That was all on today's legal news. Thank you and keep watching Verdictum and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.